Granted. Thank you.
Thank you, Counsel. Next case is UZUNBOYLU versus Vasquez.
Morning. May it please the Court, I'm Jason Herman. I represent the appellant, Mr. UZUNBOYLU. This is an appeal from a liability trial from a car versus pedestrian accident. The pedestrian was a 13-year-old. He lost his arm in the accident. There are two issues on appeal here, both involving the testimony of the state trooper who investigated the accident. The first is that the trial court allowed the trooper to testify about who he believed caused the accident, which this court has found to be reversible error because it reveals who received the ticket or who didn't receive the ticket. And the second issue...
Well, was he specifically asked that, who caused the accident, or was he asked, was there any physical evidence that showed any negligence on the behalf of the driver?
He was asked whether, in his opinion, there was any physical evidence that suggested that Mr. Contreras contributed to cause the accident.
That's different than how you characterized it a minute ago, right? He didn't testify who caused the accident. He only testified as to whether there was physical evidence as to whether the driver did it. There could have been non-physical evidence that showed that it was the driver's fault, right?
I think in a academic situation, yes, there could be non-physical evidence. I mean, here the officer's testimony is characterized as being his observations only. And when he testified that there was no physical evidence, you know, that he didn't testify he had done any kind of calculations. I mean, all he did was look at the scene. And so when he says there's no physical evidence that suggests it, I mean, he's really saying there's nothing that suggests it. And when you look at how that testimony is summarized in the opening statement by Mr. Contreras, it's not no physical evidence, it's the officer determined there was no improper driving on the part of my client.
But that was not objected to in the opening statement, was it?
That was not objected to, no.
For it to be error, it would have to be fundamental.
Well, unless that was consistent with the the trial court's ruling when, you know, pre-trial, there was a hearing on this testimony because the officer only testified via video. So there was complete knowledge of what this officer would testify about. And there was an objection to the officer testifying about that statement about contributing cause to the accident based on the physical evidence. And the trial court said, it overruled that argument and said that it was preserved for appeal, that the issue of testimony regarding cause and fault were preserved for appeal.
But in terms of the comments made by counsel during the opening statement, that was not, there was no objection to counsel's comment.
There was no objection to that, that's correct. And so if that is outside of the ruling by the trial court pre-trial, then the only way it's preserved is if we have fundamental error here. And in this court, we have this Elsa's decision, which talks about when there's a suggestion through implication. In that case, it was a closing argument, and the attorney said, I didn't hear the officer say it was my client's fault. And what this court said is that revealed who received the ticket. There wasn't a direct question about who received the ticket there. And that this court said that was fundamental error. And it cited to a prior decision out of the 4th District, the Anderson versus Stark case, which doesn't outright say it's fundamental error, but, well, in the dissent it does, but in the majority opinion, it talks about how that error wasn't preserved. In that particular case, there was a request for a curative instruction, and which was granted. There was no motion for mistrial, but yet on appeal, the party asked for a new trial, which was granted on a fundamental error analysis.
Let me ask you, what's the definition of fundamental error?
Fundamental error is an error that goes to the foundation of the case or the merits of the cause of the action.
Would you agree that during closing argument that I don't know if you tried the case or not, but certainly indicative that there was no belief at that time there was fundamental error because you all opposed the motion for mistrial made by the opposing party.
There was a mistrial motion made, although it was on different grounds, obviously.
Right.
And, you know, if that had been consented to, there's no reason to believe we wouldn't be here again. I mean, the officer would have been allowed to provide the same testimony.
But the point is, if the improper comment by counsel in opening statement, and it was just an oversight not to object then, but come closing time, you know, when they make a motion for mistrial, if that statement, you know, caused such harm to the trial to question the overall fairness, it would seem that would have been a great opportunity to say, we agree to the mistrial.
And, Your Honor, maybe it would have, but to me, it seems like if this judge had ruled consistently with his earlier statement that, you know, the argument on testimony by the trooper on cause and fault was preserved and it was overruled, then Mr. UZUNBOYLU would have ended up with a trial with the same error. The issue that was objected to with a mistrial from Mr. Contreras would have been off the table, but nothing that we're dealing with here today would have been off the table because that wasn't the
But what
error.
I'm saying is if the comment by a defense counsel, an opening statement, reached down to where the entire fairness of the trial had to be questioned, and then here in closing, you know, there's opposition to their motion for mistrial. It makes it hard to, you know, to come to the conclusion that you all believe that it reached down to the ultimate fairness of the trial by opposing the motion for mistrial they made. I mean, it seems more like, you know, it's a desire for two bites at the apple.
And that was certainly their argument. I didn't try the case, and obviously I wish there was a motion for mistrial, but I don't think that agreeing to a mistrial on a separate error that's raised by the other party waives the error that you raise.
It doesn't waive an error, but it does, you know, weaken your argument that there's fundamental error, what I'm suggesting.
And I understand that, Your Honor. And, you know, in this case, you know, perhaps like many cases that I've ever handled, you know, we have in the opening statement nearly a direct quote from a decision from this case, the Spinagle decision, where the trooper there testified, investigation determined no improper driving on the part of, and there he said the defendant as well. And here we have almost word for word the same statement being made by counsel for Mr. Contreras in the opening. And what that case said, you know, what this case said, and well, 2/3 of this panel said in Diaz, is that when an officer testifies about who caused an accident, and there's a revelation of who got the ticket through implication, that it does go to the heart of the case because jurors find it wholly dispositive. You know, this was a liability case only. And so the only issue here was, did Mr. Contreras contribute to cause the accident? And the officer testified he didn't. And it was summed up that way in openings with, like I said, the exact phrasing that this court has said means a party did not receive a ticket. And then also in closing, we've got this statement that about bringing Mr. Contreras to justice, you know, if he had wrongfully hurt Mr. UZUNBOYLU, and, you know, bringing to justice, you know, how else does a trooper bring someone to justice after a traffic accident but for giving them a ticket?
Other than the statement that you've objected to, what was the evidence before the jury, both as to each side's position on how this accident was caused?
Mr. UZUNBOYLU's testimony was that he was standing on the side of the road and was hit by the car. And to sum up, that was the overall theory. Okay. And then Mr. Contreras said that he darted in front of him and was hit by the car unavoidably.
And there was testimony from an eyewitness that he had darted into the street, correct?
The eyewitness was a couple cars back and said that a basketball bounced across, and then, you know, he went across the street.
Didn't his brother or somebody tell the police at the time of the accident that he ran out in front of the car?
His brother told the police, you know, the accident happened there. Okay. And, you know, pointed to him. I think his brother was 10 at the time, and that's what the officer testified to, that he was they used that testimony from the officer to impeach the brother later on, and the officer said that, the little brother told me the accident happened in the street.
And then what was this expert testimony either way?
The expert testimony, essentially the officer testified, that this was not Mr. Contreras' fault, that this was a dart-out case. The expert for Mr. Contreras described this as a dart-out case where he couldn't have been, where he was hit in the middle of the street, and he was going from the left side to the right side. The testimony from Mr. UZUNBOYLU's expert was that he was going from the right side to the left side, and it was based on where his left arm went into the windshield when he got the car. So the theory by the opinion by his expert was that he was hit on his left side then, which meant he was on the side of the road he said he was on. And that was the dichotomy between the two. And
Okay, and what was the specific argument that was made pre-trial about the officer's testimony? Was it that he could not testify as to who was at fault? Was it that he could not serve as an accident reconstruction expert? What was the argument made specifically pre-trial?
there were both arguments made pre-trial. There was a significant portion of the argument was about his expertise. There was a question that, he didn't meet Daubert, which is a direct attack on his expertise, that, just the mere, and I guess this is my second issue, the mere recitation of 700 cases investigated does not an expert make on accident reconstruction. That was argued pre-trial, but also there was argument about the specific portions of the deposition that would be played, and there was definitely, a hotly contested piece of that was this statement of, did you conclude that there was any physical evidence that Mr. Contreras contributed to cause this accident? And that was phrased multiple ways. One of them was that went to the ultimate issue for the jury, which is, what these cases talk about too, is that is the causation question. And how the court interpreted it was that that was an argument as to causation and fault by the officer. It was preserved for appeal. And when we look at preservation, the test is, was the trial court put on notice of an alleged order sufficient to fix it? And so here what we have is the trial court actually saying, you've preserved for appeal your argument on the trooper talking about cause and fault. And so we do have the trial court put on notice.
Let's assume that the officer was not qualified as an expert. Okay, the statement that the younger brother made, that wouldn't require an expert to testify to, right?
That's correct, Your Honor.
Okay. And the location of the car when he arrived at the scene, the defendant's car, that wouldn't require any expert testimony, correct?
That's also right. All his physical observations are
All right.
not expert.
And the location of where the plaintiff landed would not require any expert testimony?
That's also right.
Okay. So, other than the statement that he believed that because of where the plaintiff landed, that would indicate that he was in the road before, was there any other testimony he gave that would require some type of expertise?
He testified that Mr. Contreras did not have time to swerve, which goes to, one of the theories of, whether there was any contributory negligence here, not just straight up negligence. There's also testimony about how the body moved after it was hit, which goes into which side and where the body fell. But what the officer said is, there's no way this could have happened the way that Mr. UZUNBOYLU said, because if he'd been hit, he would have been run over by the vehicle as opposed to landing in the road. And so we have, sort of the summary of a body dynamics expert opinion given by the officer to get where he's going, as well as the testimony about the ability to swerve out of the way. And when we look at the officer's testimony about his expertise, when it comes to really anything, all he said is he's had 700 investigations each year, but that's like 3 a day. There's no testimony whether that's just taking down names and writing down what people tell him, or whether he's actually doing accident reconstruction as an expert. He certainly didn't testify at all about accident reconstruction training. Actually, there's no testimony about training of any kind or coursework.
Was there anything in his testimony that would be that he was not qualified to give in terms of any accident reconstruction, or was his testimony more accident investigation and more factual as opposed to technical, which you would normally see in a reconstructionist?
There was a blend here. I mean, a lot of it was observation, and, I think part of the problem we have here is that this was a discovery deposition taken, I think, 3 years before trial, and so there weren't, clean runs at what would be expert testimony, nor any, attempt to qualify him. But when he's talking about timing of a car to swerve out of the way, that's an expert, that involves calculations. When he's talking about how a body moves and which side he's hit on, because that's one of the things talked about too, is the point of impact on Mr. UZUNBOYLU's body, which matters in this case because it says where he's standing, which side of the road he's standing on. And those involve an expert's opinion, figuring out how a body moves, the physics of how it moves, where it would move after it's hit, and what a car, which way the car is moving. Because he says the car is going straight. Mr. UZUNBOYLU's expert says the car turned after he hit him, and those are all, those are things that require calculations, expertise, and whether the trooper truly was qualified or not, we don't know. The record's just completely barren on that. There's no testimony about any kind of accident reconstruction history, experience. There's not testimony about what these investigations entail. There's not even, testimony that this officer knew this street particularly well. He says he doesn't know if it was lit by street lights. So unless there's further questions, I'll reserve the rest for rebuttal.
You have about 4 minutes for rebuttal.
Thank you, Your Honor.
May it please the Court, my name is Jeffrey Jensen. I represent the appellees. It's our position that appellant's claim of error regarding opening and closing statements have been waived since there was no contemporaneous objection.
Do you agree those were improper statements?
I agree that it would be within the trial court's discretion to either grant a mistrial or some other curative instruction. The law is
Within
clear.
their discretion, that would indicate that it was improper.
Yes, Your Honor.
Okay.
But the law is clear that when there is an error, the litigant isn't free to just ignore it and remain silent and ask for a mistrial later. In the case Mylar Elevator Service Company versus McGowan, the court in that case said, trial counsel simply cannot allow error to occur without objection, hope they will win in spite of the error, and be confident of a new trial when the trial court has not been afforded opportunity to cure the error. The cases are legion that warn that trial counsel cannot have their cake and eat it too. Now, the court did make some preliminary rulings on the admissibility of the trooper's testimony, which has been preserved for appeal. But statements made in opening and closing that go beyond what the trooper actually said, that is a separate error which must be objected to. The cases in which the plaintiff rely upon, the Spanigal case, the Van Tran case, and the Albertsons case, all those cases, there was a contemporaneous objection and either a motion for a mistrial or a motion for some other curative instruction. On the Elsis versus Hankey case, there was a contemporaneous objection and a motion for a curative instruction, which the appellate court later found that that was not sufficient remedy. But as the court had touched on earlier today, this is not, whether or not it's fundamental error, I don't believe this was a fundamental error. The Budget Rent-A-Car versus Jana case, the court held that the citation error is not a per se fundamental error which supports a reversal in every case. And in this case, we don't have any testimony about whether a citation was issued or not. The fact of the matter was neither party received a citation. The only issues this court should consider is whether the trial court abused its discretion in admitting the testimony of Trooper Hellstrom. The proper standard is an abuse of discretion standard, and there should be a lot of deference towards the trial court's decision, and that's the Hudson versus State case that the appellant himself cited in page 11 of his brief. Florida Statute 9702, which is the evidence code, states that an expert can be qualified based upon experience alone. In the case Mathil versus Schnitzer, the court held, a trial court's decision on the qualifications of an expert is ordinarily conclusive and entitled to great weight on appeal unless it is shown the trial court applied erroneous legal principles in arriving at its decision. To qualify as an expert in given areas, it must be shown that the witness has acquired special knowledge of the subject matter, whether by study or through experience. We find that Almy's experience in investigating the causes of accidents and her years of work experience were sufficient to qualify her as an expert in accident reconstruction.
What other than I worked 700 of these 700 accidents, what other than that, what other evidence or testimony was presented by the trooper in this case that he was qualified to give expert testimony, other than the fact that he'd worked 700 accidents?
The witness testified that he was employed as a Florida Highway Patrol trooper for 8.5 years. Now, the trial court can, I believe, take judicial notice that the law requires both the Florida statutes and the Florida Administrative Code through the Criminal Justice Training and Standards Commission mandates that a trooper go through an academy and retraining periodically, I believe, every 3 years.
That's true, but that, you know, that could mean that the trooper sits out on the highway and gets tickets. It doesn't mean that the trooper is qualified to serve as an accident reconstruction expert.
Well, the troopers do go through a basic accident reconstruction training program, and then there's a higher certification as a homicide investigator, which Trooper Hellstrom didn't testify he was a homicide investigator, but this wasn't something that required a homicide investigation.
He didn't go through at his deposition, any of the, he didn't go through the training. I mean, he didn't go through his training and experience. It was very, basically, I've worked as a trooper for 8.5 years, and I've worked probably 700 accidents.
I do agree that is a bare bones resume for an expert, but I believe it's within the trial court's discretion to determine that was enough.
Was the argument made to the trial court about judicial notice and what the administrative code says and what the statute says, and therefore that's a basis on which you could determine that he can serve as an expert?
Not to that specificity. The argument basically was he's qualified because he's a Florida Highway Patrol trooper, and he has performed these investigations for 8.5 years, performing approximately 6,000 accident investigations.
Well, let's assume that he was not properly qualified as an expert in the field of accident reconstruction. What testimony did he give that would have required someone to be so qualified?
The only testimony I believe that would require the expert testimony was there was some testimony about how a body moves in a pedestrian versus vehicle accident. But if that was error, it's harmless error, because the court also heard testimony from Dr. Stern and Dr. Abel, which basically was, a repeat of the same things that Trooper Hellstrom.
Okay, so on that issue, his testimony is consistent with both the plaintiff's expert and the defense expert?
There were some differences between Trooper Hellstrom's testimony and Dr. Stern's testimony on direct. However, on cross-examination, Dr. Stern admitted that had Mr. UZUNBOYLU been standing on the side of the road and been struck while he was stationary, as was his testimony, then what would have happened is when Mr. Contreras applied his brakes, Mr. UZUNBOYLU would have been ejected off the hood of the car onto the ground, and then Mr. Contreras would have subsequently run over him. And that to have the body movement as it occurred in this case, where Mr. UZUNBOYLU rolled off the fender to one side, that would have had to have occurred as a result of a moving pedestrian. Now, the only thing that was faulted about Trooper Hellstrom is the qualification issue. There's no claim that the trooper's testimony was not based upon sufficient facts or data. There was no claim that the trooper's testimony was not the product of reliable principles and methods. And there's no claim that the trooper has not applied those principles and methods reliably to the facts of this case. The only argument is, well, all he said was he's been a trooper for 8.5 years and done approximately 6,000 accidents. It's our position that the trial court did not clearly abuse its discretion in admitting the testimony of Trooper Hellstrom. And the appellant's arguments about erroneous testimony as to who was cited for the accident is a red herring in this case because there was no such testimony. There was no testimony regarding the trooper's determination as to who was at fault. There was no testimony regarding citations, and there was no testimony that one party's actions were improper. The only question was regarding the existence of physical evidence of a contributing cause, which was a question directed as to the trooper's observations on the scene. A contributing cause is not equivalent to is not equivalent to fault. Dr. Abel testified that causative factors is not the same thing as negligence or fault. You can have a contributing factor for an accident such as standing water, but that standing water is not fault for the accident, and if it rains, it's nobody's fault that there was standing water there. You can also have improper actions that were not a contributing cause of an accident, such as an intoxicated driver who stopped at a stoplight and gets rear-ended. The jury is free to determine fault notwithstanding the absence of or presence of physical evidence.
But when a law enforcement officer, who, jurors typically trust, says that even if it's framed in terms of, I found when it was asked if any physical evidence to suggest the driver of the vehicle had any contributing cause to the accident, and the officer responds no, doesn't that in and of itself suggest that the Mr. Contreras was not at fault? Doesn't it lead one to suggest that? And when you take that on top of all the others, the counsel's statements and opening and closing, isn't that something that a jury can infer? And why would that not take the issue of comparative negligence off the table?
Well, as phrased as the court has phrased that, I would agree. However, that's not what the trooper testified to. The trooper simply testified that he saw no physical evidence that there was a contributing cause by Mr. Contreras. That's not the same thing as Mr. Contreras didn't contribute to this accident. Whether or not Mr. Contreras tried to do an evasive action or not, there might not necessarily be physical evidence of that, but the jury would still be able to opine, well, Mr. Contreras should have been more careful because he was in a residential area, and they could still find fault on that basis. And that indeed was part of what was argued. In any case, it's our position that if the trooper did testify and shouldn't have, that it's a harmless error. In the case Segura versus Mellerson, which was cited in the brief, the court held, the trial court did not abuse its discretion in allowing the trooper to offer his limited opinion on the very narrow issue of whether Segura had sufficient time and space to avoid the accident. The decision whether a witness is qualified to testify as an expert is a factual determination falling within the broad discretion of the trial court, and the trial judge's ruling in such regard will not be disturbed unless a clear abuse of discretion has been shown. The witness had been a trooper for 10 years and testified regarding his extensive experience with the roadway and median at the site of the accident. Furthermore, the testimony that the trooper gave was merely cumulative to that offered by McCarthy's accident reconstruction expert witness. Error, if any, was therefore harmless. And that's exactly what we have in this case, is if it was a error to allow the trooper to testify, I don't think it was harmless because they heard from Dr. Stern, which was plaintiff's expert, who on cross pretty much admitted that it couldn't have happened the way Mr. UZUNBOYLU described the accident, and they also heard from Dr. Abel, who testified that the accident dynamics was consistent with somebody running across the road and being struck. And then as a final point, I think, although I couldn't find a case exactly on point, I think the court should establish a rule that if there is an error that the appellant alleges is a mistrial, should be granted, that such an error is waived if they have an opposing party who asks for the mistrial and they fight against it. If there was indeed an error and they did not believe that they had a fair trial, they should have consented, yes, Judge, that was an error, we should have a do-over. They didn't want that. They made a calculated tactical decision to take this case to the jury because they thought that they were on the winning side of this argument. And I think it's a manifest injustice if, having rolled the dice and it didn't come out their way, that they get a do-over.
Well, if you moved for a mistrial based on an alleged error, and the other side doesn't agree that that alleged error was an error at all, you think they still should concede to your motion, which would in essence be admitting that that was an error when it wasn't?
Yes, because that gives the trial court an ability to cure the error that occurred
Wouldn't
previously.
their remedy be to bring their own motion based on what they think was error, not to concede to your motion, which they don't agree was error?
I agree that they have the ability to file their own, to move for a mistrial on their own. They didn't do that.
And how could they in good faith concede to your motion if they don't think that your motion is well-founded or has any basis in law or represents an actual error? Wouldn't it be some kind of an ethical violation for them to concede your motion was valid if they don't think there's any validity to it?
No, I think as a lawyer, you have a duty to ensure your client receives a fair trial. If during the proceedings something happens that takes that fair trial away from your client, and then later on you have an opportunity to cure that error and get your client a fair trial by having a mistrial declared and start over again, I think you have a duty to your client to concede to that mistrial. A mistrial itself doesn't mean that one party is at fault or, and sanctions are going to be entered against that party. It's just a representation to the court that the parties have not received a fair trial due to error. And it's really irrelevant who committed the error. If you want a new trial for your client because you don't believe you had a fair trial, that's your opportunity for that fair trial.
Well, there's two issues. One is, say, Judge, you erred in letting this evidence in, or there was an improper comment, and then there's the idea of the mistrial. I mean, theoretically, they could have said, well, Judge, we don't think that's a basis for mistrial, but as long as we're arguing for mistrial, we want to raise this, and then the judge would be faced with the situation of both parties asking for mistrial, and then the judge could do whatever the judge would want to do. But
Yeah, it is within the judge's discretion, and had they consented to the mistrial and the judge said, no, I'm not granting it, would be an entirely different situation. But in this case, they didn't remain silent about the mistrial. They actively fought against the mistrial. They tried to get this in front of the jury. And now, after all those errors had occurred, they wanted this to go to the jury. They got what they asked for. They shouldn't be heard to complain after the fact when it didn't work out the way they wanted. If there's no more questions, I'm done with my argument. Thank you.
Thank you, counsel.
Thank you. One point I want to address first off is there was some argument that this police officer's testimony didn't cut off, the jury thinking about whether or not evasive maneuvers could have been taken by Mr. Contreras. But that's actually exactly what the trooper testified about when he said there wasn't time to swerve. That he could not have taken evasive maneuvers and therefore he wasn't negligent. I want to talk about...
Let me ask you, the rule that police officer can't go to the ultimate issue on their testimony, as far as fault or citation, but if you had a case and say the police officer was properly qualified and said, based on the skid marks, et cetera, it appears that, it's my opinion that the defendant's car was going 75 miles an hour. And then the follow-up question is, what was the speed limit in that area is 45 miles an hour. Is that improper testimony?
By the police officer, I think there's cases that suggest that's not by itself improper testimony. But when you add that to further...
Right. The next question, so was the person speeding, did you give him a citation? That would be improper, but can the police officer get to the point, assuming they're properly qualified, to say that, in his opinion, the vehicle was going 75 miles an hour, and also testify that the speed limit there was 45 miles an hour? Now, it wouldn't take a genius on the jury to figure out that means the defendant was speeding, but is that improper testimony?
No, Your Honor, and we have kind of a similar situation in the Diaz decision where there was a truck that was in a roadway, and there was testimony that this motorcyclist who was the plaintiff was speeding. That's what the trooper testified about. And what the court held is that that by itself sets up the jury to understand that who got the ticket. It's not enough by itself, but then when you have another statement, not a direct statement on the ticket, because none of these cases I cite talk about direct evidence of who got the ticket, not Spinagle, not Diaz, not Elsis. But when you have evidence, well, here you've got the reverse. You've got evidence by the trooper that this guy is not speeding, and then you have him say there's no physical evidence that suggests that he contributed to cause the accident. And when you combine those, what the jury is going to infer is that he didn't get the ticket, especially when you put in the context of the statements by the counsel in opening and closing. And really when we look at just the testimony of the trooper here, which is a clearly preserved objection, that was fought, it was ruled on. It's the specific testimony in the video that was played. That yes, it's limited by physical evidence, but what this court said in Diaz, and Judge Berger, I'm going to quote you here, in response to a question regarding contributing causes to an accident, the detective testified that he was given no reason to feel there was any fault on the part of the other vehicle based on the information or the evidence that he found at the scene. There's limitation there as well. He's not saying based on calculations or anything else. There are other factors off the scene in that case too. But what this court held was that that's enough to tell the jury who received the ticket. And that was enough there to require a new trial and reverse. And we're asking that the court do the same thing here. So,
Does it make a difference that in the Diaz case that was based on the trial court's denial of a mistrial? I mean, they'd asked for a mistrial and the court denied it and gave a curative instruction, which we determined was, didn't cure the defect.
I don't think so, Your Honor. I mean, we've got an objection to the specific testimony that was ruled upon by the judge, and that's the error that we look at, should this testimony have come in or not? And the court ruled that it would come in. And the rules of evidence say that once there's been a definitive ruling, and you can't get more definitive than a ruling, that videotape deposition gets played for a jury. Once you have a definitive ruling, there's no need to renew that. It wasn't renewed, but it doesn't matter, it was preserved. And as we talked about, this court in Elsis has found that this is fundamental error. And as is in the Albertson v. Stark case, which this court relied on in Elsis, that case was not a mistrial case either. That's why this court cited it for fundamental error. There was no mistrial in that case. It's much more akin to this one. It was a violation of an order in limine, a curative instruction, rather than a motion for mistrial. And the court there said, that's enough. You don't need a mistrial. And there's cases throughout the state that say, this kind of error rises to the level, you don't need a mistrial to get a new trial. And there was no motion for mistrial here, but a new trial is nonetheless warranted. So we ask that you reverse.
Thank you, Counsel.
Thank you.